Politics exam review session. My name is Jennifer Makovich, and I teach at John F. Kennedy High School in Wheaton, Maryland. I know you're curious how to be successful. You want a little review on how to accomplish some magic on that AP exam to get that 5, so let's go ahead and get started. The very first thing that you're going to note here is that now is a great time to pause your video and to go grab a PDF copy of the question we're going to talk about today, covering Wisconsin v. Yoder. It is the SCOTUS comparison FRQ, and you get to follow along at home as I go through how to answer this question successfully. So go ahead and pause the video and grab those things, and then we'll move forward. All right, we're back and we're ready to go. When I start with this topic, I always want to tuck into where am I going to find the points on the page. So there are 3 tasks that you are assigned, A, B, and C, but there are actually 4 points that are embedded in these tasks. A good way to look at how to be successful on those tasks is to go back and start at the top. So our A point, which is asking us to identify, remember that identify means name. I tell my students to oftentimes describe them too or define them just to make sure that the points are there in case they miss something, speak or give the wrong word or something along those lines. Just beneficial to make sure that we've got all the points we can possibly get. So we could be naming a constitutional clause. Here, think the 10th Amendment, the 14th Amendment, Commerce Clause. We could be unpacking a right from one of the 10 amendments that's known as the Bill of Rights, or even the 14th Amendment. So there, it says civil right or civil liberty. You want to make sure that you're clearly naming what that civil liberty is. In this case, we're talking about Establishment Clause. And the final thing that you could expect to see on that A point is judicial doctrine. And there are a couple that we have in the course. Remember, judicial doctrine is a concept that the court has come up with through precedent that helps guide decisions in the future. Some examples of judicial precedent that you should be accountable for on the exam are judicial review, stare decisis, strict scrutiny, political question doctrine, due process, particularly procedural and substantive due process. So once we've successfully identified that A point, we're going to turn into the B point, and here you have 2 points on the page. That first point, and what we really want to aim for, is actually aiming at getting that second point. And how we earn that is by successfully comparing a required case, of which you have 14, to the given case that's in the stimulus. You're going to get a passage with a bunch of information. And there's really 4 different things that you might be thinking about or comparing. That can be the facts of the case, the holding, the decision, or the issue. I'm going to talk more about that on the next slide. Finally, when we get to our C point, we want to explain how or why concepts in the course might connect to whatever is prompted in our stimulus, in our question. So remember that we have some task verbs here. Describe, when you're describing, you might be describing the facts, the reasoning, the decision. We're illustrating, we're giving detail. And oftentimes, especially if you're talking about the given case, you can pull all of that information out of the stimulus. When it's the required case, remember one of those 14, you've got to pull that information and summarize it from your memory. The next task verb that we see here is compare. And again, you're going to be comparing. You could be talking about how they're similar or different. And it could be the reasoning, the decision, the holding, so on and so forth. So look out for what that B point's asking you to do. Finally, we're looking to explain how or why these cases are going to apply to the scenario in context. This is really important for us to keep in mind here, that College Board expects us to be able to recall the facts of the case, right? Those are the relevant events that happened before the case came to the court. I tell my students here, it can be both what the government did, think passing a law, an executive order, something along those lines, or something the government didn't do. Either way, action or inaction can set the table for a case coming before the court. So once we've established what the government did or did not do in 1 or 2 sentences, we want to give 1 or 2 sentences that is going to show what specifically occurred in violation of that law or as a result of government inaction that brought it to court. Issue is a question. It's a legal question or a constitutional question that's being asked of, in this case, the Supreme Court to answer. And they're really only asked of cases that are before appellate jurisdiction courts. So that's our circuit courts and for sure the Supreme Court. You only have to know Supreme Court cases, so there will always be a question that is asked of the Supreme Court. Remember, the Supreme Court usually does not answer questions that are outside of what's been asked of it when a case has been brought to the attention through the process of obtaining the cert. Finally, we're going to turn now into that actual decision. Holding is usually a brief statement. It's 1 or 2 sentences, and I tell my students you can find that in what's called the syllabus of the actual decision. I actually steer my kids away from websites like Oyez because sometimes those summaries, which are written by law students, aren't quite what we're looking for here on the AP exam. So again, that holding is this constitutional? Is this not constitutional? And it generally answers the question, given the set of facts in this law, this is the outcome. The final thing here is the reasoning, and that gets to why. They have to justify why they made the decision they did. And in case of all of these 14 cases that we have to know, almost every single one of them is going to result in something being declared unconstitutional. So they're going to give reasoning, and that reasoning becomes the precedent that will be used in future cases. And that becomes really important for us to pay attention to, because sometimes the cases that are before the court might impact issues that aren't directly relevant to the case. So all of this together is called the majority opinion, and it's written by the justices, usually, as it said, the majority of them, so that's 5 of the 9 decisions. You do not need to know concurring opinions, dissenting opinions, amicus curiae briefs, or anything like that for this, in terms of memorizing it and being able to recall it on this specific question.
Artistic expression begins within us.
So the last thing I want to leave you with, and this might be a good place for you to pause your video and take a screenshot, is I love to give my students sentence starters. I actually teach freshmen, and so sometimes they don't feel as confident that they're going to be able to accomplish all those tasks. So we work a lot with sentence starters as ways to ensure that they get more comfortable, and as that language becomes a part of something that is their own, they can kind of change it, alter it, because writing is an art. So here you have the stimulus and the questions, the tasks. So it's a good opportunity for you here to pause your video and to read the information. Keep in mind everything you need to know in order to compare this given case, which is Cantwell versus Connecticut, and the required case, which is Wisconsin v. Yoder, is here. You just got to find it. And don't panic if you've never heard of Cantwell versus Connecticut or any of the other information in the stimulus or the SCOTUS FRQ. You're not supposed to know it. It's a comparison and an application. So read it, identify that information, and then we'll talk a little bit about it in 1 second. The first place that I want to go to when thinking about this question is, what does the Constitution actually say? And so inside the Constitution, in that First Amendment, there are 2 clauses that are working at the same time, but they're working in opposite directions. So when we think about the Establishment Clause, it's important for us to note here that this is a restriction on Congress. Congress and therefore the government, and today, because of selective incorporation, this also includes state governments. None of those governments can force religion on citizens or promote one religion over another. So another way of looking at this is it's a restraint on the power of government on behalf of citizens. The topic of it is government and governmental power. Free exercise, on the other side, has to center the right of the citizen. So you and I, we can't be restricted by state or federal governments from practicing a religion of our preference, whether that be a religion or non-religion. This is an allowance that we can go ahead and make these decisions of our consciousness without having to worry about government burdening those activities with a motivation that might be burdensome. But there's a test involved. We have that strict scrutiny test. We see compelling, narrowly tailored, overly broad, right? And when the government has to pass that test, think of it like an argumentation FRQ. They're making an argument that when they write these laws that might impede your ability or my ability or anyone's ability from practicing the religion of their preference, they have to pass that essay test with the most compelling argument they can possibly make. And all in purpose, like when you take a look at that First Amendment, just think of that juxtaposition of restraining the government and allowing the individual. And in the middle, we have the ability for us to have a variety or a plurality of religions. Just a little summary of all of those things of how I might approach memorizing this information. All right, and we're back. So here's our prompt one more time, and we're going to tackle that A question. Again, it's identify, so that is naming. We're naming that clause that is true to both. And the clause here, it's talking about not just First Amendment. We already know it's First Amendment, so you have to unpack that and tell me which portion of the First Amendment. Here, an answer is in both the Supreme Court cases, Wisconsin v. Yoder and Cantwell v. Connecticut, the First Amendment clause of free exercise, protecting the right to believe in, but more importantly, the right to act on that belief of any form of religion was used in favor of both Yoder and Cantwell. So this actually comes from a student response, and they did a very nice job here, looking to make sure that they cover all of their bases. They identified that concept, and they earned that point where it says free exercise. It's not saying First Amendment. Move on to the B point. So the B point, again, we're explaining how the facts, so that's our very first thing that we are going to set out to do, is to set out a summary of the facts in Yoder and Cantwell, how that resulted in Supreme Court issuing similar holdings in both cases. And again, like I said, we want to be looking for the facts in Yoder, and then also in Cantwell, right? So a summary of both. Then we're going to turn to looking at how the holdings in both cases are similar. So they started out by saying the facts in Yoder and Cantwell center on families whose religious practices were deemed illegal by another state law. In the facts of Wisconsin v. Yoder, several Amish families were ordered by law that they must continue sending children to school for an education past 8th grade. In Cantwell, The Cantwell family couldn't complete their distribution of church knowledge as Jehovah's Witnesses. So we see facts of both here, and that is what we are looking for. We also need to continue on to earn both points. We have to talk about the holdings as well. And so here's where we're going to turn into talking about that the states, in the holdings in both Yoder and Cantwell, determined the states unconstitutionally violated free exercise clause in both rulings. In both cases, family rights to exercise their religious practices were violated, restricted by laws implemented by the states. So they're summarizing it and saying the holdings, the outcome, right? Unconstitutional violation, it's struck down, and that they are both operating in the same way. What I really like about this answer is that we're identifying the B1, which is our points, in one paragraph for both cases. And in our second paragraph, we're talking about the holdings. And they're avoiding overusing pronouns. Pronouns lead to a lot of confusion about who the subject of the sentence is, so make sure you reuse those proper nouns. And here we are on that final point. So we have to explain how the facts of Cantwell versus Connecticut illustrate the court's need to balance government powers and the rights of citizens. I'm going to emphasize balance here. We want to see balance in our response. So the student responds, and as you're reading along with me, you're going to notice that there's some grammatical errors. That's okay. It's not a grammar test. It's not a spelling test. As long as we can understand what you're saying, you're good to go. So the student response in this case is, Cantwell v. Connecticut demonstrates the difficulty of maintaining individual rights and freedoms while also balancing government powers and legislation, as a decision had to be made between the right to practice religion and the regulation of door-to-door solicitation. The government's responsibility to regulate this legislation while also respecting the protections in the First Amendment is something that must be balanced, as both are important aspects of society and national safety. As well as this, balancing and understanding the government's extent of influence over both enforcing necessary legislation and protecting individual freedoms is demonstrated by this case. What I like about this student response is that they're very clearly restating the prompt and saying what that balance is, right? That we have to make a decision between the right to practice and regulation. And that is that balancing government powers and regulating, as well as the rights of citizens and practicing religion. They give some more clarifying detail from the actual stimulus, and they walk out just repeating themselves to make sure that they have accomplished the task at hand. And altogether, this is a great example of how to accomplish a 4 out of 4 on this really difficult question. And all I can say is, hey man, I hope that you have the same good luck on this year's AP